Well, hi everybody. Hey, Bill O'Leary here coming to you live. And what I'm going to talk about today is incapacity, what incapacity means in elder law and estate planning. And so I'm going live. It's part of what we call our Thirsty Thursday series. So each week, for the most part, I talk about a different topic that I find interesting in sort of my 9 to 5 job, which is being an estate planning attorney, elder law. My firm is Legacy Planning Law Group in Jacksonville, Florida. So if you're thirsting for knowledge and for information and guidance, I'd like to think you've come to the right place. So again, today's topic: what does incapacity mean in elder law and estate planning? So when you're working with an attorney to prepare for your future and address the inevitable challenges that are associated with aging, you're going to come across the term incapacitated. So what is the definition of incapacity? Well, somebody who is incapacitated cannot make personal decisions or understand the effect of legal documents. An incapacitated person requires a helper, a decision maker, a surrogate, or maybe an agent under a power of attorney, maybe a guardian. So when a person has the mental state, the mental ability to execute a valid legal document like a will or a trust, this is known as having capacity. Capacity is the opposite of incapacity. So if a court finds that a person signed a will while incapacitated, the court can invalidate the will. And by the way, what are some of the causes of incapacity? Well, you or a loved one could become incapacitated for a number of different reasons, maybe including illnesses, maybe injury, think stroke, car accident, disabilities, dementia. A person with a severe developmental, disability, they may be legally incapacitated for their entire life. Now, someone who experiences a disability later in life may become incapacitated after the onset of that illness or that injury. So, for example, an older adult who develops dementia later in life may become incapacitated once the dementia progresses far enough to the point where the individual cannot understand a legal document or make personal decisions. So now let's talk about incapacity in the context of elder law. And so, elder law, what is that? It involves really preparing for and addressing the incapacity associated with illness, injury, disability, or just plain aging. It's important, I believe, to understand the concept of incapacity. It applies to powers of attorney, wills, and estate planning, as well as, if it's necessary, to obtain a guardianship over an adult. A power of attorney, as I mentioned, it's a legal document that lets you appoint someone to make decisions for you, both financial and medical. And by the way, creating a valid and enforceable power of attorney requires you to have mental capacity to understand the basic concepts and contents of the power of attorney. You don't have to understand every single word, but just generally understand the effect of what you're doing. If you become incapacitated, a power of attorney, if you did it in the past while you had capacity, allows you to preserve your autonomy because you have pre-selected an agent or a decision maker to make decisions according to your wishes. Then let's talk about a guardianship. So it's possible you might get to the point where a court needs to appoint a guardian, and that's for those people who become incapacitated but don't have a power of attorney in place. Incapacity is a central concept in the guardianship of an adult. Guardianship of an adult, it's a court-supervised arrangement where one person is going to take over or assume responsibility for an adult who is incapacitated. And what happens is the guardianship court, first has to determine if the person is in fact incapacitated before allowing someone and appointing someone to become the legal guardian over that person. And in making this determination, the judge relies on evidence from, let's say, the person's physician and others that are qualified to give an opinion of this sort. And by the way, those that may have significant autism, maybe a severe intellectual disability or Down syndrome, they are more likely to have guardians appointed for them. Making a will or any estate planning document that needs your signature, like a trust or a transfer on death, requires you to have capacity. You have to understand the basic import of what you're signing. A will is only valid if you had, as I said, the required mental competency or capacity when you sign it. By the way, the court can always invalidate your will if you were incapacitated when you signed it. And for people with cognitive difficulties, including incapacity, it's possible for capacity to fluctuate, believe it or not. A person with dementia, let's say, may cycle through periods of lucidity and incapacity, and if you get them during a period of lucidity, they may have the ability to actually sign a legal document. Now, as you age, look, bottom line, it's a good idea to meet with your estate planning attorney. Meet with them early, start the process early, begin the process of developing a will and estate plan. Dementia, by the way, dementia, it's a disease that can affect capacity, and it affects, some studies say, about 10% of adults age 65 and older. By working with your estate planner, you can prevent others from challenging the validity of your will after you pass away. Ensure that you have a valid will in place. If you'd like to know a little bit more about this whole idea of incapacity and what it means as part of estate planning and elder law, and if you want to know, hey, might we be able to help, we'd love to talk to you. So we invite you to go ahead, take that next step, schedule a free 15-minute phone call. We call it our discovery call with one of our team members. You can tell us sort of what your need is, what's on your mind. We can tell you if we can help you. Again, that call is free. Scheduling couldn't be any easier. Just go to our website, Legacy Planning Law Group, click on the Book Your Free Call button. Can't miss it. Pick the day and time that works for you. If you've enjoyed this video, please do like it and share it with your friends. And also do subscribe to our YouTube channel. We, every week, are adding more and more subscribers, putting up more and more content, getting a lot of great feedback. So we're quite gratified. So hope you've enjoyed this talk about incapacity, what it means in the world of estate planning and elder law. I'm going to give another talk next Thursday at about the same time. Again, part of our series we call our Thirsty Thursday series. So if you're thirsting for knowledge, just know we'll quench your thirst. So Bill O'Leary signing off for now. Go make it a great day and a better world.